I just finished presenting on a webinar, and what was interesting was during the question and answer session, many of the attendees were focused in on exceptions. Does my website need to be accessible given X or under Y circumstances? And what I told them was I wouldn't pay too much attention to technical legal exceptions, potential technical legal exceptions. And the reason why is this is very much a practical environment. Practically, we need to preempt litigation wherever possible. We don't even want to get into a technical argument. We don't want to get to the point where we've received a demand letter or we've had a complaint filed against us in court. We'd rather preempt that altogether and not have to deal with that. Because I can tell you that plaintiffs' law firms are not nearly as concerned with a potential technical exception as you are as the website owner. And if you receive a demand letter or you have a complaint filed against you, in effect, it is in a way a loss. And because you have to deal with that, you have to divert time and energy and money into defending against that. And that's not really a position you want to be in. Also, your technical argument may indeed have merit. I am not discounting that. But the problem is that if the plaintiff's lawyer doesn't buy into it, then you have to go and make the argument in court, which is expensive. And we don't want to go down that route. So, what I always advise is let's be practically right and not have to worry about being technically right. Now, if I was sued, would I look into those some of those technical reasons? Yes. But for now, especially as a layperson who is unfamiliar with the law, I wouldn't concern myself with these different exceptions. And on the virtual whiteboard with me, I have some exceptions. So the title here is Exceptions to ADA Website Compliance question mark. And these are exceptions that people have asked me about previously. The first one was a very popular one for a long time, and it was the 15 employees threshold. And what people did not know, and this is really until I wrote my article, and actually I will show you this article. I originally wrote an article in March 5th, 2020, and it's titled The 15 Employees for ADA Website Compliance Myth. Until I wrote this article, for a long time, even law firms had this wrong on their website, but the Google snippet was misleading. People thought if you had less than 15 employees, that your website didn't have to be ADA compliant. The 15 employees threshold applies under Title 1 of the ADA, which is completely separate from Title 3 of the ADA, which affects most website owners. But because some website owners were so focused in on finding an exception, they found one. They believed they had found one, and it was to their detriment because they never did anything for their website. And then ultimately, some of these website owners who believed this were sued. So this is why again we go to a practical landscape, because even if let's say there actually was a 15 employees threshold under Title 3, plaintiffs lawyers don't mind testing and finding out through litigation, right? So again, this comes back to we'd rather be practically right than technically right. Another exception or purported exception or hopeful exception is that I live in a different state. I don't live in California. I'm not headquartered in California, so therefore the California UNRRA Act can't apply me. My business doesn't do business in California, or my website doesn't serve Californians, and I'm based in Utah, etc. Well, that is fine, but the problem is that if the plaintiff's law firm decides, hey, we're going to file a lawsuit, then it still has the same effect. And then maybe those technical exceptions come back to help you as you are defending against this lawsuit. But then I would work on that. But for now, it's not something I would concern myself with. I would rather not try to find an exception and rather just make my website accessible to begin with. Because the other part here is that eventually there will be regulation for Title III, and it will apply, and you will have to make your website accessible. And in the meantime, you face tremendous risk. One more exception I have on the whiteboard is if you're a small business, This is not again, this is not an exception. None of these have been exceptions. If you're a small business, you still need to be ADA compliant. And so on the other side of the whiteboard, I have here, and I don't know if I've covered this, but I'll cover it again. The Americans with Disabilities Act has nothing on modern digital technology. So again, we're to this general stance where the ADA does apply. The DOJ, who regulates and enforces Title II and Title III of the ADA, has said the ADA does apply, but they haven't said exactly how to comply. And when we have these other state laws like the California UNRRA Act and then the New York State and city human rights laws, these are general anti-discrimination laws that include a prohibition against discrimination on the basis of disability. So when we're looking to exceptions to these may not, there may be an exception, but we may not know may not know what it is definitively. We may not know whether the exception would apply. And so for so many reasons, it is better just to stay out of the exception business and have that as maybe as potentially something to fall back on in the event we are sued. But I'd rather preempt litigation altogether and make my website WCAG conformant so I don't have to deal with this. So this is not something where I'm constantly concerned about my exposure to risk, and I'd rather lower the number of accessibility issues on my website, so that I become unattractive to plaintiffs' law firms. And in the event that I'm sued, I have an excellent defense with potentially, potentially having documents on, certifying my website is accessible, having a conformance statement, having a recorded user session. These are all things that can really help in the material defense. And then as far as the legal defense, there are definitely technical legal defenses that can be had and can be successful. But for right now, I'd rather not rely upon those, because when you are sued, when you do receive a demand letter, there is an implicit loss in that we have to deal with that, and I'd rather not have to deal with that. So this is my position on exceptions. I am definitely not saying that there cannot be exceptions. There certainly can be. There certainly have been cases dismissed and recently dismissed based on legal reasons, but I'd rather not get sued to begin with. And so for that reason, I recommend that website owners make their websites accessible. If you need help making your website accessible, if you'd like to have documentation that states and demonstrates that your website has been made accessible, I can help you with that at accessible.org. And I will include more information on audits, remediation, consultation, and other accessibility services in the description.